Hi, I'm Sonam Malji. In this video, I'll discuss about contract of indemnity and guarantee. Firstly, we will learn about contract of indemnity, which is defined in section 124 of Indian Contract Act 1872. What is indemnify? Here it means to compensate or to make good the loss. A contract by which one party promises to save the other from a loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called a contract of indemnity. We know that there are two parties in a contract of indemnity: indemnifier, that is promiser, who promises to save other party from the loss, and the other indemnity holder or indemnified, that is promisee. This is the person where loss is to be made good. A contract of indemnity is really a class of contingent contracts. Example: A and B go into a shop. B says to the shopkeeper, "Let him have the goods, I will see you paid." The contract is one of indemnity. Let's understand rights of indemnity holder when sued, which is given in section 125 of Indian Contract Act, which deals with indemnity holder and entitled to recover from the indemnifier. Here they are: to recover all the damages which he, indemnity holder, may be compelled to pay in any suit in respect of any matter to which the promise to indemnify applies, and to recover all the cost which he may be compelled to pay in bringing or defending such suits. But the indemnified should have acted as any prudent man would act under similar circumstances in his own case, or with the authority of the indemnifier. It means the main condition is that he should not have contravened the order of indemnifier. And the last, to recover all the sums which he may have paid under the terms of any compromise of any such suit. The compromise should not be contrary to the orders of the indemnifier and should be prudent or authorized by the indemnifier. Rights of indemnifier. In contract of indemnity, the authority of English law said that the rights of indemnifier are analogous, which means comparable or parallel to the rights of a society under section 141. The rights of surety has rights against the creditor, the principal debtor, and the co-sureties. Here, rights of indemnifier refers to rights under doctrine of subrogation, which means the right of insurer to be subrogated to the rights of its insured is typically based upon the terms of the policy of insurance, or the rights of equitable subrogation, that is by operation of law, and to sue against third party after indemnifying the indemnity holder, and not to compensate for losses not covered under contract of indemnity. Contract of guarantee. Section 126 of Indian Contract Act 1872 defines a contract of guarantee as a contract to perform the promise or discharge the liability of a third person in case of his default. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. A guarantee may be either oral or written under section 126. It may be express or implied and may even be inferred from the course of conduct of the parties concerned. With the example of contract of guarantee, S requests C to lend rupees 500 to P and guarantees that if P fails to pay the amount, he will pay. This is a contract of guarantee. S in this case is the surety, C is the creditor, and P is the principal debtor. A contract of guarantee is a triparty agreement which contemplates the principal debtor P, the creditor C, and the surety S in it. There is a triangular relationship in which the following three collateral contracts may be distinguished. The first, as between C and P, there is a contract out of which the guaranteed debt arises. Second, as between S and C, there is a contract by which S guarantees to pay to C P's debt in case of his P's default. Third, as between S and P, there is a contract that P shall indemnify S in case S pays in the event of a default by P. This contract, if it is not expressed between the parties, it is always been implied. Essential features of a contract of guarantee. First, concurrence, which means the fact of two or more events or circumstances happening or existing at the same time with three parties. They are the principal debtor, the creditor, and the surety. Second, primary liability in some person, which means that it must be other than surety. Here, the word liability means a liability which is enforceable at law under Section 126. If that liability does not exist, there cannot be a contract of guarantee. And the third, essentials of a valid contract. A contract of guarantee must have all the essential elements of a valid contract. But the following 2 points should be noted, and they are: first, all the parties must be capable of entering into a valid contract, though the principal debtor may be a person suffering from incapacity to contract. In such a case, the surety is regarded as the principal debtor and is liable to pay personally even though the principal debtor is not liable to pay. Second, consideration received by the principal debtor is sufficient for the surety, and it is not necessary that it must necessarily result in some benefits to the surety himself. It is sufficient if something is done or some principal's promise is made for the benefit of the principal debtor. The difference between contract of indemnity and contract of guarantee. Firstly, there are two parties to the contract, the indemnifier and the indemnified. Opposite to that, there are three parties to the contract, the creditor, the principal debtor, and the surety. Secondly, the liability of the indemnifier to the indemnified is primary and independent. Opposite to that, the liability of the surety to the creditor is collateral or secondary. Thirdly, there is only one contract in the case of a contract of indemnity, that is between the indemnifier and indemnified. Opposite to that, there are three contracts, one between the principal debtor and the creditor, and the second between the creditor and the surety, and third between the surety and the principal debtor. Fourth, it is not necessary for the indemnifier to act at the request of indemnified. Opposite to that, it is necessary that the surety should give the guarantee at the request of the debtor. Thank you.